Okay, welcome everybody. Thank you for joining us tonight for the Guardianship and Other Alternatives Transition Booster Session. My name is Amy Clausen. I work with Ohio Family to Family. And we have here tonight a delayed presentation. Thank you all for your patience. Technical difficulties does not escape us. But I'm so happy you could join us even though we're late. Kristen Henry is our speaker and expert on this topic that is so very important to many families when you have a child who's into adulthood with a disability or special health care need. We're still accepting participants into the session, so I'm just going to delay the start just another minute or so. Thank you again for your patience. All of your mics and videos are turned off during the presentation, so we ask that you all use your chat box. We will have time at the end of Kristen's presentation for some questions and answers directly to Kristen. And then we're going to have some families share their experiences. And I know from hosting previous sessions on guardianship and other alternatives that the parents' experiences on this is something you don't want to miss. It's very insightful, very helpful, and supportive. So again, we are recording this session. We're going to go ahead and get started. My name is Amy Clausen. I'm here with Ohio Family to Family. And our first presenter is Kristen Henry. She is with APSE, which is an acronym that stands for Advocacy and Protective Services, Inc. And I will let her get started. Thank you, Kristen.
Thanks, Amy, and good evening, everybody. I'm so glad to be here to get the chance to share my experience and some information with you that I think you'll find helpful as you make this decision. So I want to start by, as I make some introductory comments, we're going to have a few polls tonight. Just so we can get a sense of who's in the audience and what your considerations are right now. So when Amy has a minute, she is going to launch our first poll that focuses on the age of the child that you are considering guardianship for. And then also what your current plans are and a couple other questions. And then we'll refer back to those questions and answers as we go through here tonight. I see a comment about turning up my mic. I will try to speak up a little bit because I have no control over any of that. So please do keep letting me know if you're able to hear me or not, but I will try to speak up. So as Amy said, I am the executive director, of Advocacy and Protective Services, Inc. And I will skip through this first part pretty quickly so that we have plenty of time to hear from the families as you all are answering these poll questions. So APSE serves as guardian of the person only for adults with developmental disabilities across the state of Ohio who don't have a parent or another family member or friend who can support them in that way. We're currently serving about 3,300 adults across the state in just about every county, and we're the only program like ours in the state of Ohio. We are available 24/7 to provide consent, and we do that through a variety of staff members because we as the organization are the guardian, not our individual staff. We have our protective service representatives who are our primary staff that provide that guardianship service. And we also have medical specialists who consult with our staff on our clients' medical issues and help provide consent after hours. And this map shows you kind of how we divide up the state with our staff. By serving 3,300 people across the state. We do quite a bit of different activities. So in the past year, we visited our clients almost 22,000 times. We do a lot more than that in terms of phone calls and meetings with them, lots of contacts between our staff and our clients. We file reports and plans with the court every year, which I'll talk about later as a guardianship duty. A number of our clients every year move, and that's always a big process for them and for us. And with the clients and their needs, we have a lot of calls, a lot of consents that we're providing. And because we're statewide, our staff do quite a bit of traveling, which of course has been done a little bit differently over the course of the last 7 months with the pandemic. So let's see the answers to those polls. If we could close the poll and share the results with everybody. All right, so if I had to have put out a guess beforehand, I definitely would have guessed that age 17 would be our biggest number. So you families are really in that home stretch of this initial decision that you're going to make. But I love that we've got a bunch of people who are thinking about kids who are 14 or younger. Because it's so important for you to be planning. And one point I'm going to make, especially at the end of this presentation, is about how you can be using some of the services and plans that you have in place right now to prepare your child and prepare you for this decision. And it's great that we've got parents here of adults, people 18, 19, 20, over 21, because one of the points you're going to see here, even on this slide, is that the decision that you make initially doesn't have to be a final decision. It can change over time. And it looks like we've got a pretty good division of people who aren't really sure, people leaning guardianship, and people who are pretty sure about guardianship. So I'll be sure to address all of those perspectives. And then some of these last questions. Okay, very good to know. So I am going to dive right in to some of what I hope are the things that you take away from this presentation today. The first thing that I always want parents to know is that guardianship is not mandatory. There is not a certain diagnosis or a certain eligibility that says that this person or this group of people have to have a guardian. Some people, even as much as judges, I have actually heard of some judges who believe that people who have developmental disabilities must have a guardian. And that's just not true. It really depends on a lot of factors. It depends on the person's decision-making skills, most foremost. But it also depends on their family support and the kinds of decisions that they're facing. And then it's so important to know that decision-making skills change over time, and that means that the right solution for a person may change over time. I do find, because I've done a lot of presentations and talked to a lot of parents about guardianship, and one thing that they may be told or may feel is that guardianship will protect their child from certain problems. And there certainly are important authorities and important protections that are in place with guardianship, but it is not a key to solving every problem or preventing every problem. And so that's an important consideration. Okay, I'm seeing more comments that people are having trouble hearing me, and I truly don't know why. I do a lot of video calls during the day, and so I'm just gonna try to keep speaking up and hope that you can turn your volume up a little bit. So probate court appointment is required for guardianship, and that is very important for families to know, because some parents know that as their child is a minor, they are the legal guardian or natural guardian for their child. That is not the case once your child turns 18. Legally, once the child turns 18, they are treated like every other adult in society. And so if you feel like you need to become their guardian, you do have to go through that probate court appointment process. And I'll go through those details towards the end of the presentation. And then it's so important, especially because this is a presentation. I don't know which counties you all are coming from, but I can tell you that if we pulled 5 people in the audience today from 5 different counties and asked certain questions about how their county handles things, it could be different for all 5 people. Some of the questions I'm going to address today, I'll try to point out where counties handle things differently. And instead of trying to tell you what each county says or what each court would do, I'm going to tell you how you can find out what they would do and some of the things that you might need to explore. I'm sorry, I don't know why it keeps doing this. Okay. So when we talk about guardianship and alternatives, it's important to understand the difference between competence and capacity. Those terms sometimes are used interchangeably, but they really are different, although they can overlap. Competence is a legal standard and a legal determination. For guardianship, I'm quoting from the statute here in Ohio law when I say that incompetent means that the person is so mentally impaired that they are incapable of taking proper care of the person's self or property. What a legal definition, right? I mean, it's hard to really even start with what that means. But the probate court is going to make that decision based on initial expert evaluation completed by a physician or a psychologist. And even that term competence can mean different things in different types of courts. So unfortunately at APSE, because of the very complex needs and abilities of the people we serve, we tend to have clients who occasionally get in trouble in the criminal justice system. And just because they are incompetent and in need of a guardian does not mean that they are incompetent to stand trial. So they still do face those criminal charges sometimes. On the other hand, capacity is not a once for all black and white legal determination. You have capacity or you don't. It's about a specific moment in time and a specific decision you're facing. So whether you have capacity to make one decision may not be the same as whether you have the capacity to make a different decision, especially if it's on a different day or even a different time of day. You know, the medications that a person takes can affect their capacity, and just changes in their condition. All of those things can affect a person's capacity. What is very important to know is that capacity matters for the alternatives to guardianship that we're going to talk about today, because there are legal thresholds of capacity that are required for things like powers of attorney. So again, I will be returning to these themes throughout the presentation today. So if you're wondering, I don't know why it's doing that. If you're wondering, you know, how do we assess our options? How do we assess capacity? Some things to keep in mind is that guardianship does not prevent every problem, like I said before, and nor should we expect it to, or nor should we expect to prevent every problem that might face our kids. Trying to go back to the previous slide here. And that's where the concept of dignity of risks comes in. And so what that means is that we all have the opportunity to make bad choices. I typically am doing presentations like this with a can of soda in front of me. I know exactly what that's doing to my health, to my waistline, the fact that I ate a bunch of bagel bites for dinner tonight instead of a healthy meal. You know, we all have that dignity of risk. And I don't want to make light of decisions like that, because the decisions that that our children, as they're transitioning into adulthood, are facing are different from those, and sometimes they're much more serious. But it's important for us to have that perspective that we all make decisions that, number one, not everybody agrees with, and number two, that aren't always good for us. But what is important for us as adults is that we face the consequences of those decisions, we learn from those mistakes and those decisions, and then we do better next time. All right, I'm going to take just a second. Amy, I think both of us having control here is causing the slides to move forward. So I don't know if I should just tell you to advance the slides. All right, can you go back 2 slides, please? Okay, thank you. The next point I want to make as you're assessing options related to guardianship is that relationships actually can matter more than legal authority sometimes. Not always, because a doctor is going to treat a guardian differently than a non-guardian all of the time, or should. But the relationship between the person under guardianship or the person who is being supported in different ways with the person supporting them is absolutely as important. And that is because guardianship cannot override a person's actions all of the time. And so an example for us is sometimes courts or county boards come to APSI and say, we need you to become this person's guardian because they are not taking their medications. Well, at APSI, we can certainly consent to medications. We can consent to an ISP with the county board that says that the provider will give the medications and refill the prescriptions. But in the end, if the person closes their mouth and will not take that pill, there is nothing that a guardian is going to do to force that pill down that person's throat. And so having a relationship with someone who says, hey, Bill, I know that you don't love taking this medicine, but here's what the doctor says it's going to do for you. And don't you like being out of the hospital instead of in the hospital? And this is going to help you. So all of these things are more important sometimes in a specific situation than actually having the legal document of guardianship. And so the flip side of that is, if you're concerned about whether you should become your child's guardian or not, it can make a big difference as to whether you have a good supportive relationship with that child and they're willing to take your advice and willing to take your suggestions for how they handle things and talk through those decisions with you, than if you are constantly in tension and locking heads with each other, which I know can be hard to assess sometimes with a teenager. But those are one of the things that you should keep in mind. And then I also really emphasize for people, especially as we talk about alternatives to guardianship, that decision making is a skill that can be developed for a lot of people. And as that skill develops, maybe guardianship was necessary when the person turned 18, but it isn't necessary anymore once they turn 25, and it's appropriate then to look to those alternatives. All right, Amy, you can go forward 2 slides, please. Oh, I'm sorry, no, stop on that last one. It's all well and good to think about some of these ideas in the abstract about capacity and different levels of support. But if you want to get down into the details and try to think through, okay, what does my child need help with? Where are they independent? Where do they have capacity? Where do they need support? These are 2 documents that I really like. The second one is a broader document, kind of looking at different issues and alternatives to guardianship. The first one, though, is one of my favorites. It used to be called the stoplight tool because they had a different red, yellow, green color scheme. But this charting the life course, if you haven't heard of charting the life course, you probably will soon. It's a big push with the Department of Developmental Disabilities right now, and it can really help adults, transition age youth, all of those groups who are trying to plan for their lives. And one of their tools that I really like is this exploring decision-making supports tool. And what it does is it breaks down big categories into much smaller decisions. And then you kind of have these columns where you say, my child does this independently, my child does this with support, or my child needs complete assistance. And then as you assess those things, it can help be a guide for where your child needs help and whether guardianship or an alternative would be appropriate. Okay, Amy, now you can go forward 2 slides. All right, so let's get into the details of guardianship. As I said before, probate courts in each county in Ohio appoint guardians for adults who are not able to make decisions for themselves because of a disability. So please remember that the court has to appoint the guardian, and that as a parent, you are not automatically your child's guardian. And then the key role of a guardian is to provide informed consent. but it must be within the scope of the guardian's authority. And so it's actually interesting to me that the statute, the rules in Ohio still say that a guardian's duty is to protect and control the ward. I don't know who has much luck protecting, let alone controlling anybody these days. But I don't feel like that's an accurate description of what guardians do. So I really focus on kind of the concrete duties that a guardian has. And the main one is you're providing consent. You're stepping in those shoes to agree to whatever it is that's put before you. All right, let's go to the next slide where we talk about the different kinds of guardians. So the kind that APSI is, at our organization, we serve as guardian of the person. And most of our clients, that's the only guardian that they need. And often that's true for other individuals who receive developmental disability services. So that guardian of the person is going to make those daily living decisions and provide consent related to things like, where is this person going to live? What services are they going to receive in their service plans, their residential providers, what programming they're going to have, what behavioral supports, and then anything related to medical treatment, medical services, psychiatric care, medications, all of those things. So anytime you go to the doctor and you're signing consent to receive treatment, anytime you go to the dentist, anytime you have surgery, all of those things, that's where you're giving consent. A guardian of this estate, on the other hand, handles financial matters, money and property. So in Ohio, there's typically a threshold that if the person has less than $25,000, that they typically do not need a guardian of the estate. And now that we have stable accounts, where you can kind of have some protection for those funds and have a designated person to assist with spending those funds. Really, if as long as the funds are in a stable account, you really wouldn't even have to address guardian of the estate, even if it was more than $25,000. And then property would be, for example, if someone inherited a house or other kinds of property or had a bunch of things to manage. So guardian of the estate is those financial matters. Any of those guardianships can be limited by the court. So for an example, some of our clients that we serve are pretty independent, but they have a complex medical situation. And so we are designated as their guardian for medical decisions only. And then just to make sure everyone's familiar with the term, I included on this slide that when I say ward, which I try not to say because I feel like that's a pretty outdated term, that means the person who has a guardian. So if I do mention that as part of the legal terms, that's what I mean by ward. All right, let's go to the next slide, Amy. So in addition to providing informed consent, a guardian is always required to follow orders of the court, that probate court, local court rules, and then Ohio Supreme Court guardianship rules, which is Rule 66. The probate court is the superior guardian. And so what that means is if a matter comes to the court's attention, they can direct the guardian to act in a certain way because the guardian or the probate court is the boss, and then the guardian is like their agent, even if it's a parent. That's especially true for guardians of the estate. Now, this is an area where some courts handle things differently, but technically a guardian of the estate must receive approval for every single expense that is made of the person's funds. Some courts will give kind of a threshold approval. Some courts will give categories of approval. Some courts literally require every single expense to be pre-approved. And some banks will follow that as well. So even if your court doesn't require that, some banks for liability purposes, if it's a guardianship account, will require a court order to pay anything that is presented to the bank. Guardians are also required under Ohio Supreme Court Rule 66 to receive 6 hours of initial training and 3 hours of annual training related to guardianship. This is definitely an area where courts handle things differently. Some courts routinely waive that education requirement for family guardians. Other courts do not. even if your court does waive it, I encourage you to check out those resources and kind of do them on your own time. They're free, they're online. Once the pandemic's over, they'll be in person again, but also available online. And they really do provide a lot of good resources, a lot of good information. There are some specific to the DD system that I find very helpful. Guardians are also required to file an annual guardianship plan and an annual guardianship report, sometimes with an expert evaluation addressing the continued need of the guardianship with the court. This is another area where some courts will terminate the need for expert evaluations based on the person's diagnosis and prognosis. Some of them require their plans or reports on a different schedule. They definitely handle those differently. Guardians are also required to notify the court of certain things. Courts are required to be notified about moves where the person is living. If it's to what's called a more restrictive setting, so maybe moving from your home into an intermediate care facility, that would be, or a nursing home, that would be considered a more restrictive setting, and the court actually has to approve that in advance before the move can occur unless it's an emergency. Guardians are also required to report certain allegations of abuse or neglect to the court. This is something where the rule text is not super clear, and so each court handles it a little bit differently. And then any other changes in the individual's status. So if there's a change in their need for the guardianship, the guardian needs to report that. Next slide, Amy. So just want to emphasize again that guardianship is not always the answer. So if there's a problem or an expected problem that you're facing and you think that guardianship is the answer, make sure you're specifically thinking through what would a guardian do to change the situation. And then I also like to emphasize that not every decision needs to be made or should be made by the guardian. And that goes back to some of that dignity of risk and all of that. And so the easiest example is what a person should wear. Certainly, if a person has a guardian, that doesn't mean that the guardian is required to pick out the person's clothes every day. It also usually means that the guardian doesn't need to decide what they're going to eat every day. Now, that's where we start to get into gray areas when people have very significant dietary restrictions or health and safety risks related to certain foods. And that's not why we're not getting into all of those details today. But not every decision needs to be made by the guardian. It is completely appropriate for a person to have some decision-making abilities even when they have a guardian. Next slide. So it's also important to be aware of what the legal limitations are. So we talked before about guardian of the person versus guardian of the estate, limited guardians. And so a guardian can only make a decision or give consent for something that is within that authority. At APSI, because we're only the guardian of the person, we spend a lot of time marking out consent forms that say that we release legal liability or financial liability, or that we guarantee payment, because that's not within our authority as guardian of the person. That's one example. If a guardianship is limited, so for our clients who were guardian of the person for medical only, we have no authority to give consent to their residential providers or what activities they're going to do. And then there are some legal restrictions about some of those very personal, intimate decisions. So for example, guardians cannot give consent to procedures that would sterilize the person. That's for kind of human rights protections. And another very important thing in the DD system that has been around for about 5 years now is conflicts between what a guardian wants, what a court might order, and what the DD system allows its providers to do. So in particular, there's a rule called the Behavior Support Rule. And that rule has restrictions on what county boards can authorize and what providers can do related to aversive measures or restrictions. And so even if a guardian says, I want this to be locked up, if it is not approved through that DD system process, a provider cannot follow that. And then, like I said before, there are practical limitations on guardianship. So just because we have the authority to consent to something doesn't mean that the person will follow through. And there may not be anything that we can do about that, because for example, we may consent to a person being involved in a certain day program. But if they're not going to get on the bus that day, it's not like we're authorizing them to be restrained onto the bus. So just keep that in mind as you consider some of those scenarios for guardianship or some of the alternatives. Next slide. All right, so this is an issue we hear about periodically, and I think during the pandemic, it has kind of taken on new life. And this is definitely an area where counties handle things differently. In fact, I was recently on a call with a handful of probate judges, and each of them had a different way of handling these situations. So the situation is being a paid provider through maybe a Medicaid waiver for your adult child who you are the guardian of. So there are a couple of Ohio Supreme Court rules on this. Some of them seem to conflict each other. Some of them aren't very closely defined. And so that's where you get courts who have different rules. So I've listed on this slide what the rules say. And as you can see, the general guide is that guardians appointed by the probate court cannot be paid service providers. However, this is definitely an area where some courts will allow family members to be a paid service provider. Other courts will never allow a family member or non-family member to be a paid service provider. And I think it's helpful to know the context of why these rules exist and why courts are sometimes hesitant if you're in one of those counties. So the first issue is not an issue that applies to parents, but they want to make sure that there's not a conflict of interest of, for example, a nursing home administrator becoming the guardian of people who live in that nursing home. Obvious conflict of interest. But then even when you take it to the family context, there can be conflicts of interest between a parent choosing themselves as the provider. Now, I am sure that every parent who is on this presentation today is totally above board and wants only the best for their child and would love to have a different service provider if you could only find one who could do a good job. Unfortunately, there are too many examples out there of times where the guardian has served as the paid service provider and there's been abuse or neglect or exploitation. And so that's why some courts who have seen that in their counties are very hesitant or completely resistant to allowing guardians to be paid service providers. So really, you just need to find out if that's your situation. You need to find out what your court thinks, and when they do allow it, what kind of evidence or support from the county board they require. So again, can't get into details of this county does this county does that. You really just need to follow up with your county to know the situation. Next slide. All right, so another important thing to remember about guardianship is that guardianship does not terminate all of the rights of the person who has a guardian. But again, this is something where the law is not always 100% clear, and I have heard judges from different counties express completely different views on the subjects. So again, if you're digging into an issue, we are happy at APSI to provide some technical assistance. If you want to ask kind of how your county handles things, we can tell you what our experience has been. That's also a good time to talk to other families in your county who have had similar experiences. A couple things that I always highlight are, first of all, voting, which is a very timely topic right now. A person who has a guardian in the state of Ohio still has the right to vote. There is a very, very little used process in state law where a probate court could find someone incompetent for voting purposes. But I will tell you, I have never talked to a probate judge, and I've talked to a lot of them, never talked to one who's actually done this. And so it's pretty safe to presume that in Ohio, a person who has a guardian still has the right to vote. But ever since the first time I did this presentation to a group of parents and heard this question and nearly made my heart stop, I have added, especially when I talk to parents, that does not mean that the guardian can vote on behalf of the ward. It is the person's right to vote, not their guardians. So I have had numerous parents say to me that they request their adult child under their guardianship's absentee ballot and fill it out for them and return it. That is voting fraud. Please don't do that. If your child wants to vote, they are able to vote. They can be helped to vote, whether someone they choose, like you, to fill out their ballot, or there are procedures under the law for people with disabilities to get help from poll workers, either in advance of the election with an absentee ballot or on the day of the election in person. So please do encourage people to vote if they have that interest. Occasionally I'll have people say to me, well, they're incompetent. How can they decide who to vote for? That's probably thrown around as a question of anybody who is on opposite political sides right now, is how can they make the decision? They clearly don't have an appropriate thought process if they're voting for this person or that person. So I think, we see a lot of examples of people voting for different reasons, or because they like the person's name or whatever, and we don't deny that right to vote based on whatever criteria you have to people just because they have disabilities. Driving is another one that people, I think, have some misinformation about. There is nothing in the law that says that if you have a guardian, you cannot have a driver's license. There is a process in the law where the BMV can be informed of concerns about whether a person has capacity to drive, and then they can consider that in granting the license. But sometimes we have clients who say they want their guardianship terminated so they can get their driver's license. That's not necessary. And another great thing that's developing with technology is, I can't tell you all the places, but I know that there are some places across the state that have like driving simulators where a person who might have a disability that could impact their driving abilities can go and kind of almost do a simulated driving test and identify areas of improvement, or kind of identify, we had one client in particular who her reaction speed just is not fast enough to be a safe driver. And so we had to work with her to move on to a different goal for herself. Marriages, relationships, sexuality, that's where we get into the really sticky stuff. You take people's very strong opinions and add them to an unclear law, and you kind of get a mess. And so I have heard probate judges say that a person who has a guardian clearly would not have consent to engage in sexual intercourse. I've only heard one judge ever say that. I personally don't think that that is the law, but that's, again, if you were in that court, you would need to know that that was their perspective. Or vice versa. If a court heard that someone was being restricted from dating someone just because they had a guardian, they might be concerned about overstepping there. So again, know your court, and there's a lot of freedoms and rights that still exist for people who have guardians. So I think it's probably safe to assume that people do have the right if it's one of those very personal decisions. And then if there was a need for restrictions based on health or safety or significant threats to them, that's where we would probably go back through that DD team process. During a guardianship case, a person has rights like the right to have an attorney appointed for them if they can't afford one, the right to get an expert evaluation if they can't afford one themselves. And so those are all rights that they have, just like anyone else would have in court in a particular kind of case. And then, as I mentioned before, those DD system rights, the rights of people with disabilities, those apply outside of guardianship and when a person has a guardian. Next slide. All right, go on into the alternatives. So the reason to consider alternatives is because guardianship, if you're looking at things kind of on a spectrum, guardianship is the most restrictive option. It takes legal rights away from the person and gives them to someone else. It also is long-term. Sometimes parents have the misconception that because they have to file a report every year, that means the guardianship has to be approved every year. And that's incorrect. Guardianship continues indefinitely unless someone petitions the court for it to be terminated. And some alternatives to guardianship can be very effective in individual situations. And for those situations, research shows positive connections between that kind of self-determination and better health, safety, independence, and integration in the community. All good things. All right, let's move on to the alternatives. So I want to start with what I said before and what's at the bottom of this slide. Capacity matters for these alternatives. So sometimes we have parents say things like, well, I know that my son or daughter would qualify for guardianship, but I just don't want to go through the probate court process. So we're going to do a power of attorney instead. You know, if that's the right decision for you, great. But your child has to have legal capacity to understand the power of attorney that they're granting, or else that's not an effective legal document. So that's just one example as we go through these. So the first alternative to guardianship is informal supports, which basically just means the exact way you help other people in your life. If maybe you have a parent who is aging and going to doctor's appointments and they're having some trouble understanding the situation, and so you go with them, you listen to the doctor with them and help them ask their questions. That's an informal support. And for some transition age youth with disabilities, that works for them. They have a good relationship with their parents, they're willing to have that support from their parents, and there's no need for a more formal alternative. Supported decision-making is one that I'm going to talk more in detail on the next slide. So for timing reasons, I'm gonna move on right here. Releases, authorized representative, that addresses the situation for parents, which I hear a lot. Parents who say to me, I need to be my child's guardian because I need to know. I need to be able to call the doctor and find out what's going on. I need to be able to call the school and find out what's going on. And they say I can only do that if I'm the guardian. Well, there's truth to that, and then there's missing truth to that. So the truth is, yes, if there's not a legal authorization for a doctor to give you information, then once your child turns 18, they can't give you that information. But just like I, as an attorney, could get documents for my clients with their written release, so could a parent. If their child, adult child, signed a release saying you're allowed to talk to my parents about my medical condition and my treatment, that is effective. Sometimes that's called an authorized representative. Powers of attorney are legally recognized documents. For some healthcare powers of attorney, there's actually forms in the statute or authorized by statute that allow someone to act on someone else's behalf. So it's kind of complex legal terms, but power of attorney means I'm saying that you are my attorney in fact, which has nothing to do with being a lawyer. You are the person who is able to act on my behalf because I have designated you as that in this document. And so I'm the principal in those documents and you're the attorney in fact. And so for people who maybe don't have a lot of complex decisions they're facing, who have capacity to make decisions typically on their own, or they just want to designate someone to make some of those decisions for them, that can be very effective for financial and healthcare matters. And I do recommend that you meet at least briefly with an attorney to make sure that those documents are filled out correctly. For financial matters, there's a number of ways. As I mentioned before, most people that we serve do not need a guardian of the estate because they do not have over $25,000. If you are doing planning, I know that Family to Family offers sessions on special needs trusts and things like that. And that's a way that you can avoid a guardian of the estate is through trust planning, through being a payee on Social Security. Even with the reporting that has to be done to Social Security, I can tell you it's much less than what has to be done for being guardian of the estate, and then stable accounts like I mentioned before. Conservatorships are interesting because I look at them as basically a voluntary guardianship. So a conservatorship is initiated by the person who is asking someone else to help them. It looks very much like a guardianship because it is still presented to the probate court, approved by the probate court, overseen by the probate court, but it's voluntary and it's not based on a finding of incompetence. All right, let's go on to the next slide. So supported decision-making is one of my favorite alternatives to guardianship, and it is really building up in popularity and in support in Ohio. I get a lot of questions, and I've seen it a couple times in the chat already. Does Ohio recognize supported decision making? So the good news is yes and no, but by no, I mean it doesn't have to. So here's what I mean by that. Ohio law is written pretty broadly that if there is an alternative to guardianship that can support a person's needs, that's a reason not to establish a guardianship. Some states, like Texas, have created laws specifically about supported decision making. There's supported decision making forms that have to be filled out and processes that have to be followed. And in some ways, that kind of puts it on that rote version of guardianship. And so in Ohio, we don't have legal requirements for supported decision making. Supported decision making doesn't have to be a process or a form or a program. It's a paradigm, it's a way of thinking, it's a way of looking at a situation. And so what it means is going back to some of those capacity assessments I was talking about earlier, figuring out, where does this individual need support? Where do they need help? Where can they be independent? And then find a way to provide that help. So the idea is that we all get help making decisions. I do not make every decision independently. I talk to my husband, I talk to my parents, I talk to my siblings, I talk to people who I know who are experts. I'm certainly not a car expert. And so when something's wrong with my car, I usually talk to my father-in-law because he is a car expert. And so we can't expect people with disabilities to have this magic ability to make decisions all by themselves, or they have to have a guardian, because we don't make decisions all by ourselves. And so if you're interested in supported decision making, what that really means is you're going to sit down with a team, whatever team means for you. Maybe it's an SSA at the county board. Maybe it's educators. Maybe it's you and your family, and you're going to make a plan. When my child, and it's kind of from their perspective. So when I need help with things related to medical, this is who's going to come with me. This is who I'm going to talk to. When I have issues related to my job or planning for employment, this is who I'm going to talk to. It really is as simple as that. And like I said before, the good news is this is really developing in a lot of counties in Ohio. Many of them are creating programs to support families who are choosing supported decision making. So if it's something you're interested in, contact your County Board of Developmental Disabilities and see what they or their Council of Governments, they might have a regional collaborative that is doing things related to supported decision making. Next slide, please. I will skip over this except just to say, even as a guardianship organization, we are adopting supported decision making. We are working with clients we have to get them restored to competency so that they don't need a guardian anymore, and helping bridge that transition for them. And we are also working with organizations to identify people who could use a little help with decisions but don't need us to become their guardian. And we're trying to help them get through those decisions and then continue on in their independence. And it's been exciting and it's been beneficial, and we love this work, and we're going to be doing a lot more of it over the next few years. All right, next slide. Okay, before we turn it over to the families, I have a few really concrete tips for you. In that poll we did at the beginning, some of you said that your child is receiving services related to decision making, which is fantastic. And if you're interested in learning more about that, supporteddecisionmaking.org. Even if you're not sure about supported decision making in general, there are a lot of good presentations on supporteddecisionmaking.org. It's listed at the end of these slides that talks about ways that you can get services through school at the IEP, through vocational rehabilitation in the IPE, through DD services in the ISP, to address decision making as a skill. It is legally supported. If you look at the laws that establish those programs, they absolutely can be used for those kinds of categories of issues and skills. And supportive or assistive technology can also be used. Sometimes a person has difficulty following through with decisions or communicating decisions, not so much making the decisions. And for some of that transition into independence, things as simple as reminders on a phone or having a quick way of connecting with someone else who can keep them on top of things, a visual schedule on a phone, things like that can go a long way. Next slide, please. All right, so couple tips about probate courts. I've mentioned several times that every probate court has different ways of doing things. Sometimes people call it the 88 states of Ohio or the 88 fiefdoms of Ohio for each of the counties. If you want to find out what is relevant to your county, I usually start by Googling just your county and then probate court. So Cuyahoga County Probate Court, and then some of them will have the packets that you need to fill out for guardianship or phone numbers of people you can call. Some of the larger counties in particular will have a designated person who answers questions about guardianship. I will caution you that they can't give you legal advice, but they can tell you what forms the court requires. They can tell you things about timing, because a lot of people worry, okay, you've said that once my child turns 18 that, I'm not automatically their guardian. Well, does that mean I have to schedule a hearing on their birthday? A lot of counties will do that. They'll make sure that if you've got your paper in time, that they'll schedule a hearing on that 18th birthday so there's a seamless transition. Some will even do it shortly before the birthday. So it's good to talk through that timing with the court staff. Those education requirements. Do you need to do the pre-service training? Do you need to do the ongoing training? Do you need to do annual reports every 2 years? Is an expert evaluation required? If you are a service provider under the waiver or something like that, then you can ask them what's their process for approving direct services providers. What kind of background check do they require? Some, as long as you've lived in Ohio for 10 years, only require the in-state or BCI background check. Others require everyone to do the FBI background check. And then co-guardians. Let me talk about co-guardians for a minute because it comes up with a lot of parents. Some courts don't want to appoint co-guardians. Even if it's a very happily married couple, they want one person to be the designated guardian. Some courts will allow you to be co-guardians, but they specifically say in the letters of guardianship that the co-guardians must sign off on everything together. Every document that one guardian signs, both have to sign. Other courts are fine with just one of the co-guardians signing things. So that's something to keep in mind. Both how does your court handle it, and then how does that impact your decision? I will say that if there's one person who typically is more involved with the administrative things, I think it can be a lot simpler for one person to be the co-guardian. But if there's maybe both parents do traveling for work and one's home for a while and the other one's with them for a while, if that can fluctuate, that may be a situation where a co-guardian makes sense. I would say definitely if you're in a county that requires both guardians to sign everything, you should think long and hard about whether it makes sense to do that, because you're putting yourself in for probably a lot more burden than it's probably worth. But this takes us into our next slide about the process. So generally the process is you're going to file the application with a bunch of forms that the court requires. The court's going to schedule a hearing. They're going to serve what's called the next of kin. That's going to be parents, possibly adult siblings. If any of those family members are not in the picture, there might be other next of kin that have to be served. And then the court investigator is going to do usually a face-to-face. They're probably doing virtual visits now, because they have to notify the person of their rights, and then they kind of do an interview and make their own assessment about whether guardianship is appropriate in this situation, and then they file a report with the court. You are able, if they don't automatically send you that report, you are able to request a copy of the report before the hearing. At the court hearing, the court reviews the information, takes testimony. If it's not an opposed guardianship, if the whole family supports one parent becoming the guardian, it can be pretty pro forma. You come in, you swear to tell the truth, you swear you're going to do all the things you're supposed to do. They have you sign an oath of guardianship, and they give you letters of guardianship. And then there's those ongoing reporting responsibilities that we talked about before. Next slide. So another thing that I know parents sometimes wonder is, do you need to have an attorney if you're going to pursue guardianship, or a power of attorney, or supported decision making, or whatever else? I said before that I think powers of attorney, it's helpful to have an attorney to look over those forms. There are basic forms that are available online, but a lot of attorneys have developed more robust forms, and then they can help you confirm that your child has the capacity to complete those forms, because it's part of their responsibility to make sure that's done correctly. If you're going forward with guardianship, you're really going to think through your comfort level with filling out those forms, your comfort level appearing at that hearing by yourself or with an attorney. If there are service issues, maybe parents are separated and you don't have a good address for the other parent, that could potentially cause issues, so you might want an attorney's help. If there's going to be conflict, if two or more people are going to be fighting over who the guardian should be, always good to have an advocate as an attorney on your side. Certainly, if you're going to be the guardian of the estate, with all of the court approvals that would need to be gone through and the reports and things like that, that would lean in favor of having an attorney. But then obviously there are financial considerations. You know, attorneys typically are not free. I do know in this area of law, there usually are attorneys who understand the needs of this population, of your families, and try to have very reasonable fees, or kind of show you what you can do on your own versus what they can help you with. And one of those things could be reporting things to the court for you, or showing you how to do that on your own. Next slide. Go ahead. So these next two slides just have a bunch of links. I think these are, yes, they are going to be on the website, which is in the chat. DODD has a nice pooled resource on guardianship. I mentioned supporteddecisionmaking.org before. The Jenny Hatch Justice Project is a great story of a young woman with Down syndrome who was able to use supported decision making instead of guardianship. Ohio's DD Council has a great pamphlet on guardianship that's very helpful for families, and Disability Rights Ohio has good resources on guardianship as well. I think that takes us to the end. So I am happy to take questions, but I also want to make sure that we hear the family experiences. So I will take Amy's lead on what we're doing next.
Thank you, Kristen. I would love to take questions after the families share some experiences, just because I know that the families on the call today really want to get everything, you know. So if I could ask the Debbie and John and Tina to unmute themselves and turn on their cameras. And then we'll do questions for everyone all together at the end of the session. So please stay tuned. You don't want to miss this. John, are you on with us?
Yes.
Good, there you are. Thank you. Let me clean up here a little bit. Thank you, thank you. All right, so let's have John get started, if you would, kick us off with share a little bit about yourself, your family situation, and what your current experience was, because I know that you recently went through this decision-making process, so that's your unique experience of the night. Would you mind sharing just a little bit about how you made the decision and a little bit about you and your family? Thank you.
Sure. My wife and I, we have a daughter who turned 18 just a little less than a year ago. And when we came to time for guardianship, it was something we always thought we would do. And we went to a lot of presentations, especially by Amy through the years with Family to Family. And when we got close to the point, one of the big points, and you heard Kristen talk about it too, is trying to find the least restrictive support. So that kind of made us rethink, oh, well, gee, are we jumping to a conclusion? Let's really think about it. And so it kind of made us do a lot of soul searching, and it was good, but it kind of led us back to, yeah, this is what we think we should be doing it. So if anything, it kind of confirmed that we were on the right track. Um, Specifically with our daughter, she's verbal but not conversational, and decision making is not her strength. She can be indecisive, and sometimes yes means no and no means yes. And we were concerned that other people may not understand the decision she's making. And we were also concerned that sometimes certain words could trigger her being a little anxious. And, somebody may ask, well, is it all right if the doctor talks to your parents? And all she'll hear is the word doctor. And immediately say, no, 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 just because she doesn't want to see doctors, because who wants to see a doctor? So those were the kind of things that led us to know for our situation, guardianship was the way to go. And we're in Cuyahoga County, and it went pretty smoothly. And now we're coming up on the year of it when we'll have to start doing reports.
Thank you. And you did mention that you sought an attorney's guidance, consulted.
Yeah, so what we did is when we got close to that time period, we did meet with an attorney, and it was more to consult, not just on guardianship, but frankly, it was all the things that go along with turning 18. So guardianship, SSI, transitioning from school. So it wasn't just about guardianship. If it was just guardianship, I don't know if we necessarily would have gotten one, because you can go to the probate court's website. All the paperwork's there, so you can print it ahead of time. You don't have to worry about going that day and filling everything out. They also have what they call a resource center, and unfortunately, I think it's closed due to COVID. But you can make an appointment with them for 30 minutes. They're not going to give you legal advice, but they'll actually talk to you about it so you understand it, and even walk you through the forms if you had any questions. So we found that helpful too, because it just kind of reconfirmed we were on the right track, and there were one or two things that we questioned, and that helped us. So that, along with just going to webinars all these years, no matter how many times you hear a topic, I've always walked away finding at least one new thing. So I'd encourage everybody to continue doing what they're doing tonight.
Yes, okay, good. Thank you for clarifying. I did not know that Cuyahoga County had a resource center. Of course, probably not now during COVID, but maybe the counties in which our participants tonight have something similar, or they could provide resources over the phone as well. So thank you for sharing that. And Tina, if you would go next, would you share a little bit about you, your family, and what decision, how you made this decision?
Okay. Hello, everyone. Can you see me okay?
Yes.
Okay. I'm a mother of three. My youngest is, he has multiple disabilities. Down syndrome is one. From the beginning, I knew that I would need to obtain guardianship with him. He talks very little. Communication is really pretty much zilch, but he won't be able to take care of himself at all. Can't even tell you 1 + 1 or anything like that. I attended a seminar. I believe I received his in 2014. So we were able to go to a seminar, and it was really interesting. And I went and did it on my own, actually, and it really wasn't no problem. Received what forms needed to be completed. With me being a single parent, the forms my two sons, older sons, had to complete, as well as my son's father, which was at the time barely in his life, saying that they had no problem with me being the guardian. And went there, filed the forms with the court. They sent someone to my home to speak to my son, and it just so happens the day that the court appointed, I guess you might say, a trustee came, I had to be in the office, but he was here with my son and my mother and my aunt, and they said they all had a good time. He was very comfortable, and he saw what he needed to see, and I think he stayed like an hour, 2 hours. Then I received notification of when to go to the courts, and just raised my hand, and that was really it. I have, let's see, last year I was able to do a report. So I was able to do everything prior to where now you have to take a course. The report that I did was a plan, the report, and I received the doctor's evaluation, again stating that my son is not competent enough to take care of himself. I'm trying to recall how much it cost. It really wasn't that much to file the forms. And I keep the guardianship papers with me at all times. I have needed it when he has had different types of surgeries. I hand it to the medical people. If anyone goes to question, my authority, I have no problem. I have guardianship because he can't communicate any kind of way. If you ask him a question, one time he was in the hospital and they asked him, was his stomach still hurting him? And he was like, yeah, and no, and all at the same time. So, me being around him all his life, I'm able to decipher a little bit better. So I haven't ran across any problems. Again, I didn't need any attorneys, but it's up to you how you feel comfortable. I was able to refer another single parent where they wanted to know how they can get guardianship for their children. Both of her children needed guardianship. And I checked with the courts and received what all forms needed to be done and forward the information to her. So I didn't see any complications. And again, I'm in Cuyahoga County. And so I found them very helpful if you needed any questions. Thank you.
Thank you, Tina. Very, very helpful. And Debbie, you have some additional ideas, unique experiences, if I recall, that maybe can help some families who are on this call today. Would you please share a little bit about your family and the different types of decisions you've made?
Well, we live in Cuyahoga County as well. I'm afraid you're only getting the perspective of one county, and as Kristen said, things are different in different counties. But I have 6 adult children, and 2 of my children have Down syndrome. One has Down syndrome with autism, and then the other one just has your standard run-of-the-mill Down syndrome. But I made different decisions for both of them based on their strengths and their abilities. So my son is very verbal, and he's got a lot of pragmatic skills. He has 0 academic skills. He can't even read a menu sufficiently to make choices. But he does have the ability to say, let's ask my mom, or I want my mom to be here with me, or no, this hurts, but this doesn't. So for him, I got durable power of attorney. Now, like Kristen said, I have, I'm the rep payee for his SSDI, and he owns no property or anything of that matter. So being his durable power of attorney, I can then say to a doctor's office or whomever that, I have the right to hear, what you need to tell him. I can be there to listen to that. It gives me the ability to make decisions for him about his money, but also about his well-being and his care. But he actually makes pretty good decisions for himself. So I think for right now, and it may change, but for right now, I think durable power of attorney works for him. I didn't choose that consciously when I consulted a lawyer about guardianship and I explained what my son was like. He said, I don't think he needs guardianship. Would you consider him incompetent? And I said, no, actually, if I dropped him off in downtown Cleveland, he would get back because he knows where he is all the time. He makes good decisions. He communicates his needs. And as long as he doesn't have to read a bus schedule, we're good. So my daughter, on the other hand, has limited verbal ability. She's pretty oppositional. She tells everybody everything's awesome. So if a doctor went in and said, oh, I think we need to do a lobotomy today, she would say, awesome. So she could not be trusted to make good decisions, nor would she insist that I be included in any kind of capacity when decisions, medical or otherwise, have to be made. And in her case, her judgment is really poor. She has a seizure disorder, and if I did not have guardianship, she would engage in activities that would promote those seizures. And, you know, there are certain triggers that I know she, you know, that cause her seizures to happen more frequently. And she would engage in those activities that would trigger those. So for that reason and many, many others, she doesn't have the ability to care for herself, to plan for herself, or to make or execute any decision making. And in her case, I don't think supported decision making would be helpful at all. So that was the basis of both of my decisions. And, you know, I agree that getting guardianship is pretty easy in Cuyahoga County. I understand other counties are more difficult. I did not have to take classes. I even said I would take classes when they sent out an email, but they never required me to take classes. I have to file report every 2 years for the guardianship, and that costs $5 to file. And for having power of attorney, I don't have any follow-up tasks to complete. Did I answer all the questions, basically?
You're awesome. Very thorough, and thank you for remembering the classes. I know that there are other families who've asked me that recently, and here's again where every county is different on the classes. The fees are also different county to county, so it's very important for me and others to remind families to look at your individual county probate website and give them a call about all of that as well. Thank you. Wonderful, wonderful. All three of you gave a little bit different perspectives. So if Kristen could pop back on, we're going to address some of the questions. And for those participants that are still on the call, as long as you need us, I'm able to stay on. I don't know about all of the speakers today, but the first question, Kristen, is about someone's daughter who is 44, and the family wants to know how to get started with rethinking that perhaps she might need more support than the power of attorney. What would you suggest? Because I know some resources you gave might be an option.
Yeah, so I think there's a few different ways of handling that depending on kind of what you feel comfortable with. So there's lots of online resources that you could check out at supporteddecisionmaking.org and other things. You can talk to, if you're involved with your county board, SSAs tend to have a lot of experience and could talk to you about different alternatives that they see used with the people they work with. You can call APSI. Sometimes we can give that kind of technical assistance. But I think that I think it was Debbie who gave the example of talking to an attorney and saying, this is the situation, and the attorney was able to say back, you know, I don't really think you need guardianship there. If you're going to talk to an attorney, I would really highly suggest that you meet with an attorney who does a lot of work with families with special needs. Because if you just go to an attorney who does a lot of estate work and they don't have a lot of experience with people with disabilities, they may only know about guardianship. But more experienced firms that really specialize in that, in a pretty brief consultation that won't cost you a lot of money, can kind of give you their perspective on kind of those legal and practical situations.
Mm-hmm. Would you recommend this family and others to start with the stoplight tool?
I think that's one of the great resources, is just kind of going through and checking those boxes can be a helpful way of starting that conversation to see what is she independent with versus what does she need complete support with.
Yes, and as I recall, the stoplight tool is very easy to follow, and it'll
Yes.
say, if yes, then go on to this set of questions. If no, then you may have this other set of questions.
Yeah, I
Something
like
like
that. It's
that.
very concrete. Mm-hmm.
Okay, good.
There's one question here in the chat that I can
Yes.
answer very quickly.
Go ahead.
Whether you can combine alternatives such as an authorized rep and a power of attorney. Absolutely. Absolutely you can. So you can kind of make the right solution for you and your family.
Good. And I see there's a question here from Becky. Did you see that one?
Yes. So I was reading through that. And so I think the question is about if you apply for guardianship and the probate court investigator needs to come out to do the interview. I think that's what you're talking about. And if so, typically in the application to the court will ask, you know, what is the best place for this evaluation or this meeting to occur? Or they'll say, who can we contact to set it up? If you give your phone number, then when the probate court investigator is planning for the meeting, they'll call you and you can say, I think it would be best for you to meet with her at school. Let me connect you with the school staff to get that scheduled. So that absolutely is something that they could do. And really they typically want to meet with someone in a place that is comfortable for them, because they know that this is something people don't really do. And it might be weird for them to be meeting with a new person and talking about all of this legal stuff. And so they're very skilled usually in bringing it to the right level. Is there a criteria or quiz or guide for capacity? No. And actually that's another thing that I've heard different legal opinions about what capacity means. So an attorney that we work with a lot basically says a good rule of thumb is, do they understand what it is that they're signing, what it is that they are essentially asking to be done? That's kind of that bare minimum of what would be required for capacity. Oh, and I'm sorry, Becky, I see your follow-up question. No, typically courts do not require every person who's the subject of the guardianship proceeding to attend the hearing. And I think, in fact, in a lot of cases, they don't come. That's part of why the probate court investigator meets with the person outside of court. And so that's something you could let the probate court investigator know. So unless your child were to say, I want to be in court, they typically would not require that.
Could I ask Debbie and John and Tina, how was going to court? That's a question that we get a lot, is how intimidating is that? I have my own experience, but I want to hear what what you felt and during and after, if one or all of you want to chime in.
This is Tina. I was comfortable with it. It wasn't intimidating. When the judge, they took me to his office and he looked over briefly the forms and everything. And he said, "Do you have any problems?" I said, "No." And he had me raise my hand, and he read off about swearing something, and I do. And that was it. And I thanked him and I left. So it wasn't intimidating at all.
How long did it take?
Um, Not even 5 minutes, really.
Really? Good.
Mhm.
John, how about yours?
It was a good experience as well. As Tina said, I think the key is, at least in Cuyahoga County, you don't go into a courtroom, which might be kind of intimidating. You just go into an office. I think we were there a little longer, maybe 15, 20 minutes, but as it was mentioned earlier, it's not required that your child come in or whoever you're seeking guardianship of. But what we were advised, and I think it was good advice, obviously it depends on your situation. We did bring our daughter to kind of make her feel like she was included in the process. And I think she
Nice.
kind of enjoyed being there, and the judge was very nice. And I think it just kind of added a little something to it. But obviously it depends on your situation.
Very nice. Debbie?
So I did this in 2008, which is quite some time ago, and I do not remember a home investigator coming to my house at all. So I brought my daughter to court with me because I wanted the judge to see through conversation with her that she was in need of a guardian. But I blew this up in my head far bigger than it really needed to be. I intimidated myself. I went in and he was as nice as he could be. He tried to get her to talk to him for a few minutes and then, did the raising your hand and signed off on guardianship. So it really isn't something to be afraid of. And if I had to do it over again, I wouldn't have bothered with a lawyer and I would just, do it myself. And yeah, I felt that they were very kind in the court in Cuyahoga. And, as John said, it's in an office. It's not in a courtroom. It's very easy, relatively.
Very
Easier than a
good.
lot of other things we've had to do for our kids, right?
Yes. Very true. So are there any more questions? I know it's late. We're late. It's 8:36. I'm happy to stay if you have more questions. Here's a good one. Oh, maybe a comment here. Let's see. Parents and Families, Ohio Network for Innovation.
While you review that, I'll jump to the next question about guardianship
Yeah.
in one county, but then you move. So
Thank
that's
you.
one thing that's kind of a technically yes, but it's not like your guardianship ends because you've moved from Cuyahoga County to Lorain County. Once it's clear that that's like a permanent move for the individual, because it's based on the person's residence, then you can work with the two courts to transition that guardianship case from the one court to the other. That's again something that every court handles differently, how they want that to happen. So I would say, go through your move first and then go through that process. But that is not the same answer I give for if you are moving out of state. State laws about guardianship are completely different from state to state. There is a special law on out-of-state guardianships. I never use it, so frankly, I'm not that familiar with it. But that is something that I would seriously recommend that you contact an attorney if you're planning an out-of-state move to make sure that you get through those steps correctly and to avoid any gaps in authority as much as possible.
Yes, on a personal level, I did move from another county and it was very easy. I got a lot of guidance from my current county by picking up the phone, and they walked me through it, exactly what to do. So that's usually fairly simple, transferring that. Don't forget to fill out our evaluations. Thank you all for joining us tonight. I think we've hit every question, and this was such a good presentation. The families, thank you all. Debbie, John, Tina, thank you all. Kristen, you were awesome. I know the families and everybody attending will get a recording and One last question. What is rep payee for SSI?
So that means if a person is not able to handle their money on their own, then Social Security can designate a person who receives those funds and manages those funds on their behalf. Representative payee.
Thank you. And that is it for tonight, you all. Thank you. We're going to sign off. Have a good rest of your evening. Bye, everyone.
Bye-bye.
Bye.
Wow.
Bye. Thank you.
Thank
Bye-bye.
you.
Thanks. Bye-bye.